What is breach of contract? A breach of contract unveils its complexities when parties engage in an agreement, only for one to fall short of meeting their contractual obligations without a valid legal justification. Once an agreement is reached, each party is bound by legal obligations, making the contract enforceable. Decoding the mechanism of a breach of contract. Contracts, often laden with intricate legal language, can be challenging to decipher. It's no surprise that breaches of contracts are not uncommon. Some contracts span numerous pages, and the specifics may fade away over time after the dotted line is signed. A breach of contract transpires when a contractual party fails to fulfill the specified obligations agreed upon in the signed contract. Ramifications of contract breach. Legal agreements usually outline the consequences of breaching the terms. For instance, a contract might stipulate a fine for a party being 1 day late on a payment. Consequences can extend to immediate contract termination or any mutually agreed upon legal repercussions. In the event of a breach, the initial step is often not a rush to court. Parties involved typically attempt to find a resolution or draft a new contract, considering developments since the original agreement. If a resolution isn't reached, mediation, arbitration, or civil court litigation might follow. If a party succeeds in a breach of contract claim, they may recover damages, including punitive measures for bad faith, enforcement of contractual obligations, or cancellation of the agreement with the return of received benefits. Varieties of contract breaches. 1. Minor breach. A minor breach might involve delayed delivery of goods or services, especially critical when time is contractually emphasized, and deadlines are missed. 2. Material breach. A material breach occurs when a party violates a substantial part of the contract, jeopardizing the entire agreement. 3. Anticipatory breach. Anticipatory breaches transpire when a party foresees their inability to fulfill contractual obligations in advance. 4. Actual breach. An actual breach takes place when a party entirely fails to meet contractual terms, prompting the other party to determine the appropriate course of action. 5. Mutual breach. Mutual breaches involve both parties desiring to breach the contract, leading to a joint decision to step back from the agreement. By understanding the intricacies of breach of contract, parties can navigate potential pitfalls and foster smoother, more legally sound agreements. Frequently asked questions, FAQs, understanding breach of contract. Q1. What is considered a breach of contract? A breach of contract occurs when at least one party fails to fulfill the agreed upon obligations outlined in a legal contract without a valid legal excuse. Q2. How do breaches of contract commonly happen? Breaches can occur due to various reasons, such as delayed deliveries, failure to meet deadlines, or a party's anticipatory awareness of their inability to fulfill contractual obligations. Q3. What are the consequences of breaching a contract? Consequences vary based on the contract terms but may include fines, immediate termination of the contract, or legal actions. Q4. Is going to court the only solution for a breach of contract? No, parties often attempt to resolve the breach outside of court. This can involve negotiations, drafting a new agreement, or resorting to alternative dispute resolution methods like mediation or arbitration. Q5. What is a minor breach of contract? A minor breach typically involves a party failing to deliver goods or services on time, especially when the contract emphasizes the importance of timely performance. Q6. Can a breach of contract be anticipated? Yes, an anticipatory breach occurs when one party foresees their inability to fulfill contractual obligations and communicates this in advance. Q7. What is a material breach of contract? A material breach is a significant violation of a contract that jeopardizes the essence of the agreement. Q8. How is a mutual breach different from other breaches? Mutual breaches involve both parties willingly deciding to breach the contract. Q9. Can punitive damages be awarded in a breach of contract case? Yes, if the breach involves bad faith, punitive damages may be awarded in addition to other remedies. Q10. What steps should be taken if a breach of contract occurs? Initially, parties should attempt to resolve the breach through negotiation or the creation of a new agreement.